Welcome, everybody. Thank you very, very much for coming today. So our objectives are to support and improve Woodbine community living through sharing information and having community events and opportunities. We are not a third-party liaison or mediator solving individual problems between a resident and park management. But we are collecting and sharing information with residents about living in a land lease community. We have the Nova Scotia Legal Information Society, Nicole Slaunwhite. Thank you, Nicole.
Okay, thanks so much for having me here. So I'm Nicole. I'm with the Legal Information Society of Nova Scotia. On my slides, we have our logo and the website, which is legalinfo.org. So I don't have cards to pass around today. We largely try to be paperless to save some printing costs since we're a small nonprofit. But if you go to the website, there are 3 ways to get in touch with us directly. You can call our legal info line on the phone. That's open weekdays, 9 to 4. If the line is busy, because we do get quite a lot of calls, or if you prefer to communicate in writing, you can live chat with us on our website. So if you have internet access and you want to talk to somebody right away in real time, we have a chat box that will pop up and it'll say either you can ask questions and there's somebody available, and that's one of our staff people. It's not a chat bot or an AI or anything like that. It's a real person who can answer your questions. And the other way to talk to us is through email. So you can email us at questions@legalinfo.org. And all that information is on the website if you don't have a pen or something handy right now. So we don't represent clients. We don't do things like go to court or prepare legal documents for you, but we help people resolve their legal issues by answering legal questions, discussing what their options are with them. If they need to fill out forms or they're representing themselves, we can look at the forms and sort of walk through that with them if they have questions about how to do that. Most of my presentation will focus on estate law, and there's a bit in there about some Residential Tenancies Act sections because it overlaps with some of the estate questions that you've had. So I'll go through the slides that I have, and then if we still have questions about those 2 sort of main issues that are on the agenda, we can talk about those in a bit more depth, and then I can take some questions if people have them at the end. If I'm not able to answer your question, if it's very specific or I just don't know the answer off the top of my head, then I'll invite you to just email us and we can answer that after we have a chance to look into it a bit more. So the topics I'm going to cover in these slides are buying and selling manufactured homes, death of a tenant, and dispute resolution. So this is directly from the Residential Tenancies Guide about land lease communities. And they say when a tenant plans to sell their manufactured home to someone who will keep it in the same space in a land lease community, the potential buyer needs the landlord's approval to become a tenant. The potential buyer can either sign a new lease or take over the existing lease. And so that buying and selling would also include disposals of property. So if you're gifting it to a family member, if the estate of somebody is dealing with a property and they need to transfer it to somebody else, or if they're going to sell it to somebody else. And I'm going to talk a bit more about how an estate transfers property a bit later on. And you'll find that in non-land lease communities as well, in any sort of rental property, landlords often don't want to accept lease assignments or lease takeovers, and that's not an option for them without a good reason. So what they'll often try to do is sign a brand new lease with a new tenant, because then they can increase the rent and the rent cap won't apply. But if they're having a new tenant take over a lease, then the old rent and the rent cap still applies. And I've experienced this myself when I was living in a building and leaving to move somewhere else. The building didn't want to have the new tenant take over my lease. They wanted to have a brand new lease so that they could avoid the rent cap. And the information sometimes that landlords will give tenants is just not accurate. They'll say things like, you can take over the lease and that rent amount will apply, but at the end of that lease, it doesn't renew, you have to sign a new lease. That's one of the most common things that we have landlords telling tenants in Nova Scotia. I've heard landlords say that that's what the Residential Tenancies program will order. I can't speak to what they'll do in any particular case, but the law says that a lease assignment should have the same terms of the existing lease. So the rent cap would apply, the lease would renew with the same terms. If the landlord is telling you something different, then you can apply to residential tenancies and ask them to make a decision. If residential tenancies does not decide in a way that you feel is consistent with what the Residential Tenancies Act says or what the law says, you can appeal that to small claims court. So residential tenancies officers are people just like everybody else. Sometimes they might apply the law differently than you think is correct. Sometimes they might make a mistake. You can't apply or appeal to small claims court just because you don't like the outcome. So if you look at it and you say, it does sound like they've explained their legal reason and they're right, and I just don't want this to happen, that's not a good grounds for appeal. But, I'm not sure that this is the correct outcome is certainly grounds for appeal. If you're looking at this and you're saying, I still think that there's some sort of legal problem here, or this is not making sense, or this is unclear, you can follow up with residential tenancies, ask them for a copy of their decision. They'll send you something in writing, and you can take that to small claims court and appeal it. Another useful thing to keep in mind is that going to residential tenancies or small claims court takes time, and that can be good or bad depending on the situation. So if you're in a situation where you wish you had an answer right away, you may have to accept that going to residential tenancies takes time. It's usually a matter of some weeks before they can schedule you for your hearing. And then if you have to appeal it, it's going to be more time to schedule it with small claims court. On the other side of that, if you have something like an estate matter where somebody's just passed away and you can't agree with the landlord about what to do with the lot that their modular home was on, applying to residential tenancies will get you a decision eventually about what should happen, but it will also give you more time to figure things out. So if the landlord is saying, I'm going to take this action, and you don't feel it's the correct action, you can file your complaint with residential tenancies, and neither the landlord nor the tenant can take further action until there is a decision that's been given by residential tenancies. And if you decide to appeal that, again, the matter is stayed or put on hold until you get a decision from the small claims court. So the landlord cannot arbitrarily or unreasonably withhold consent for the new buyer to take over the lease. And I do have some slides about this that I'll put up in a minute, but I'm happy to chat about it now. The seller's responsibility is to inform the landlord that they're selling and to give them in writing notice of this. That includes the proposed buyer's contact information, name, references that the buyer has provided. The buyer has to agree to a credit check. There's a list of reasons the landlord can refuse a lease takeover, and they're specific reasons. So if it's not one of those, they can't refuse. If the tenant and the landlord can't agree, or the landlord is refusing and the tenant feels it's arbitrary or unreasonable, the answer is going to be to apply to residential tenancies for a decision. And when I get to my dispute resolution section, most of the time in a dispute with the landlord, the answer is going to be apply to residential tenancies. And then if you don't like that answer, go to small claims court. And residential tenancies also has a function of mediation. So aside from just having a hearing, they can try to contact and work with the landlord for you if you're having trouble communicating with them. So dispute resolution usually looks like try to resolve it informally. Knowing your rights can go a long way to saying, look, you can't actually do this, and let's not waste our time and money fighting about it. And after that, going to residential tenancies, and if that's not successful, appealing to small claims. If there is a complaint, it would be until the transfer happens, the buyer, who would be the complainee or complainant. But since the matter concerns both the buyer and seller, I don't think it would be unreasonable for both of them to apply. So to say, we both have this complaint and we're filling it out jointly and we're going to file it. If residential tenancy says no, it should only be one person, then it would be the seller, so the current owner, who would file the complaint. I expect that the buyer would need to be involved in the process by contributing information, things like, here's all the info I provided, I had my references, I had my credit check. Everything was properly given to the landlord and they're not agreeing. And then residential tenancies will compare that to the list of reasons they're allowed to disagree with a lease takeover and make a determination from there.
The recommendation, if there is like selling or you're planning to make a move or do anything, you want to do it 2 or 3 months in advance. If you're like, hey, I'm gonna list this place for sale, You want to do it a few months in advance because you're notifying the park that you're starting to move, and they're going to send the lot inspection form. They're going to go through your inspection and say, you got to fix your heat tape, you got to do this, you got to do that. Or they give you a list, hey, you got to remove this deck and build it according to size. They'll come up with the list. And also at the time, you're going to want to request the lease assignment. So that way, if they tell you no, you can file your Form J. They've given me conditions of sale, given me this lot inspection form, expecting me to spend $5,000, and they're refusing my lease assignment. So there's your Form J filing that legal aid or us, we can guide you in the right direction to make sure you get the correct forms. So that's a reasonable approach. But we're talking more about what we can do for wills and estates.
And it is all connected. So, it sounds like there's been some situations where someone's passed away and a remaining occupant of the property is having issues with this sort of thing. So, certainly they do overlap. So that's where coming back to knowing your rights can be quite beneficial. So if a landlord realizes that you are aware of what your rights are and that this will take time and effort and possibly legal fees on their part to resolve it, yeah, then they're more happy to negotiate. So the next slide is about a sale by estate. So if the estate of a deceased tenant wants to sell the modular home, they have to provide the written request to the landlord. The buyer has to consent to the references and the credit check, which is what we were just talking about. These are the reasons a landlord can refuse a lease takeover. If there's info missing from the request, so if you've not given them all of the things required, like the references, if the buyer's refused a credit check, if you've not given them correct contact info for the buyer and they can't contact them. After checking references, if the landlord believes the buyer won't comply with the lease or rules of the community or cannot or will not pay the rent, they can refuse a lease takeover or a new lease. That can't just be that, like, I got a bad feeling about this person as a landlord. It has to be there is something real in the reference check and the history of this person as a tenant. So if their previous landlord says, well, they didn't pay their rent and I had to start eviction proceedings against them 3 times, and then, they always paid up at the last minute. That might be a valid reason for a landlord to say, okay, I don't think they'll pay their rent. But even then, that's a subjective decision the landlord's making. So the new potential tenant could apply to residential tenancies and say, I was late with the rent, certainly, but I ended up paying it. I was not evicted in the end. So just because they weren't willing to work with me and they started proceedings doesn't mean that I'll never be able to pay the rent again. So I can't give you a yes or no residential tenancies who they would side with in that situation, but that's an example of tenancy matters are not often clear cut, and everybody's looking at it from a different perspective. But if there have never been any issues and the reference checks and the credit check is fine, then the landlord can't just decide that they don't feel this person is going to be able to pay their rent. If the landlord couldn't contact one or more of the references after making every reasonable effort, and they have let the prospective new tenant know of this issue, and still couldn't resolve it, then the landlord could refuse the new tenant. So every reasonable effort does not mean I called a couple of times. It means, I called a number of times. I asked the potential new tenant if there was a different number or way to reach the person. I asked if there was someone else I could reach on their behalf. So if it's a landlord and you can't reach the building supervisor, call the property management office. Call, if they own another building, call somebody at that building. You have to make real reasonable efforts to contact these references. If the landlord believes the buyer doesn't plan to live in the home because the buyer plans to use it for business or because they already own more than one manufactured home in the community, they may be able to refuse the new tenant. So the owning more than one manufactured home, they're trying to avoid people buying properties and just renting them out to people who aren't going to live there, because then you end up with sort of absentee landlords in the park who are not invested in maintaining the quality of life there. But if you were, let's say I own one modular home in the community and I'm buying another for a family member to live in, and I'm still going to be living there and we're going to be neighbors, that may not be a valid reason for the landlord to deny the new tenant, because it's clear that I am going to live in the property. I'm not using it for business. it's going to be for a family member. So there are situations that are not going to fall within those scenarios, and a landlord couldn't reasonably say they thought that you weren't going to use it for living in or a family purpose. If the home has been removed or destroyed, obviously the tenant can't live there. If there's an order from residential tenancies or small claims court against the tenant for rental arrears, the landlord could deny the new tenant moving in. And if the home doesn't meet municipal bylaws or rules for the community. And I think this speaks to one of the issues that the community nonprofit was dealing with, which is this list of costly repairs or renos that has to be done. Municipal bylaws is a fairly easy one to compare. So you can say, like, is this safe and up to code? But rules for the community are things that the landlord sets. Those have to be the rules that already exist. The landlord can't make up new rules because you're trying to sell or dispose of a property. Also, if the landlord has been aware of and allowed some sort of
Offense.
variation from the rules or like a fence or a deck or something, they can't later say, I've changed my mind and this isn't up to code. So the landlord will be expected to abide by the kind of existing relationship they've had with the tenants and the property. So if they said, you know, I don't like the deck that you put on, but you asked them a year ago and they said, no, absolutely, that's fine, build the deck, that's great. They can't ask you to then remove it and replace it unless there's some sort of safety issue. So remaining tenants after somebody passes away. If a tenancy is terminated for health reasons, reduction of income of one tenant, if one of the tenants has to move into a care facility, or if there's the death of a tenant. The remaining tenants can sign a new lease with the landlord. The landlord cannot withhold the consent arbitrarily or unreasonably. And that's going to be true of most things about landlords. So in the Act, it says in lots of different places, cannot withhold consent unreasonably or arbitrarily. There has to be a valid reason. The Act doesn't discuss whether a rent cap still applies in the situation of remaining tenants signing a new lease. My interpretation of it is that the rent cap should apply, but I'm not the residential tenancies program. So if you went to the residential tenancies program because you and your landlord disagreed about the rent cap in that situation, the obvious argument you make would be the intended purpose that the government was trying to accomplish when they put the rent cap in place was that tenants not be required to pay amounts they can't afford or be displaced because landlords are increasing rents unfairly. And so if it's going to be the same tenants who've always lived there, minus the one who's passed away or had to move or had a reduction of income, the purpose of the rent cap would be to allow those tenants to continue residing there. I can't predict what would happen in any individual case. That would be my understanding of it, but residential tenancies can maybe clarify that or...
So for remaining tenants, this is the big question, and it may be in another slide, but if someone's there living as a tenant and then a care facility or something was worth, couldn't they do a lease assignment? Does it have to be a new lease?
They could do a lease assignment, yep. It doesn't have to be a brand new one. If a tenant passes away...
yeah, this is the gap where they passed away and it's after the fact of what do people do. We're trying to get to a point where people know what to do first to get set up properly. If
somebody has to move to a care facility or they pass away and there are other tenants listed on the lease, not just occupants, and I'm going to talk about occupants in a minute, the expectation would be they notify the landlord of what has happened, they sign a new lease with the landlord, but it's essentially a takeover. It's the same terms of the existing lease. The effect would essentially be the same. So the remaining tenants would be asking, look, this person's gone. They can't be in a contract with you anymore. So we need to sign a new contract confirming that, we're the tenants now. This was also the person's wishes who's deceased now. If there are no remaining tenants, so if there are people living there who are just occupants but not listed on the lease, or if the person lived there alone and there's not anybody living there who wants to take over the unit, and they're in a fixed term or year-to-year lease, there are two things that can happen. The first one is the personal representative of the deceased can give 1 month's notice to end the lease. So if they said, we just don't want to deal with this. Here's our notice. We're going to move the home. We're going to sell it to somebody else, whatever. Or B, if the personal representative doesn't give notice, the lease continues in effect and the estate is the tenant, basically, until they do give notice or the last day of the rental period, immediately after the rental period in which the tenant dies. So you could have the lease in effect for a period of months after the person passes away, which gives the estate time to figure out things like if they have to go to probate, if they have to sell it and they need to list it and find, a buyer for it, if there needs to be time to consult with a lawyer or just for the family to figure out what they want to do. So the lease isn't automatically terminated when a person passes away. It remains in effect until the personal representative gives notice or this period of time has passed. And the definition of tenant in the Residential Tenancies Act includes an heir, an assign, or a personal representative. So an assign is somebody you assign your legal rights to. So it might be, somebody who has power of attorney and is acting on behalf of someone else if they're moving to another facility or they no longer can make their own decisions. And that's coming from, I think it's Section 2 of the Act that provides definitions. So if you look up definition of tenant, that's included in there. Some important points to remember. Occupants don't have the same protection as tenants. So if possible, it's a good idea for all adults living in a rental property or a land lease community to be listed as tenants on the lease. You can't do that with minor children because they can't enter into contracts, but if you're going to be having a common law partner move in, or you're going to have an adult child or friend or roommate or somebody move in, it's a good idea to have them on the lease. You can ask the landlord to do that. Again, the landlord might try and say, well, that's a new lease, and now we have to raise the price.
And do a lot inspection.
And do a lot inspection and all these things. They don't have to do those things. They might want to do those things. You can let them know, I don't think that the Residential Tenancies Act requires that, and if we can't come to an agreement, I'm going to have to file my complaint with residential tenancies, and then they might be willing to work with you, and if not, your option would be to go to residential tenancies and ask for an order saying, they're not allowed to raise the rent. They're not allowed to make you do a bunch of repairs. As a first step, just try to follow up and see. If you're going to residential tenancies, you'll want to be able to show them that you have tried to resolve this informally and you've taken your reasonable steps. So if you've had one communication with the issue and the person's not gotten back to you, try and follow up with that person, see if you get an answer. It sounds like that answer may not be forthcoming. If that happens, you can ask residential tenancies to order that people be allowed on the lease. So essentially you'd be asking for your mother and yourself and your brother to be the assignees of her lease.
And that's through a Form J?
Yep, pretty much any time you want to go to residential tenancies, it's a Form J. Well, if it's affordable for you, it's never a bad idea to get some legal advice. Also, unfortunately, sometimes people respond better to communications from a lawyer because it looks more official and scary. The next step would be to file with residential tenancies, and you're asking for an order allowing you to assign your lease to yourself and your children. You have matrimonial rights. So the next point on this slide is that common law spouses aren't heirs and don't have a right to inherit property or divide estates. But if you are legally married, you have the right to share equally in your spouse's property. So if your partner passed away or was no longer able to live on the property, you're still listed as an occupant, it sounds like, but they can't just treat you the same way they would a roommate because you are a married spouse. You do have certain property rights. So if they are not willing to put your name on the lease in that event, that would be, again, a situation where you can apply to residential tenancies and say, this person should be allowing me to sign a new lease. The estate would be the owner of the property and the owner of the lease, basically. And I assume you would be probably the executor of the estate, in which case you aren't giving notice that you're terminating the lease. So you can continue to live there while you try to work this out with the landlord. If you can't work it out with the landlord, you can apply to residential tenancies and say, I'm the new owner of the property, I represent the estate of the deceased and I am their spouse, so I have property rights, including the right to continue this contract, I'm looking for an order for a new lease from the landlord on the same terms as what was there before. Oh, it's certainly easier if its name is on the lease. Yeah, if it sounds like the issue is there are a lot of repairs or things they want you to make. So the first step would be have the inspection done. It might turn out that everything's fine and they say, go ahead. If they don't, and there are repairs that are legitimately needed for safety or to comply with municipal bylaws, you may be looking at having to do those. If there are things that you feel the landlord is unreasonably or unfairly asking you to do, and they're not related to safety, they're not related to existing community rules or municipal bylaws, then you can go to residential tenancies and say, this is an unreasonable and arbitrary withholding of consent because they just don't want to do this thing. Yeah, moving a shed 2 inches, yeah, but being asked to move a shed 2 inches, depending on the situation, if it's not a big deal to move it and you can do it easily in an afternoon with some friends, you might as well just do it and save yourself the hassle. If it's a whole production and it's going to be expensive or not possible for you to do, then residential tenancies can say, that's not a safety issue, there's not a municipal bylaw issue, you know, we're not going to enforce that. So some options for common law spouses. If a tenant doesn't wish to include their common law spouse on their lease, or there is some reason that they can't, so maybe there is some, you know, maybe the landlord says, oh my gosh, you need a new roof. This roof is 40 years old. And you just don't have the money to do that right now. You know, maybe you're not going to put the person on the lease because you can't meet the terms of this inspection. And, you know, these things happen. So if that's something that you're dealing with and you do want your common law spouse to inherit your home, you can consider creating a will that names the spouse as an executor and gifts them the home. So the person who is sitting next to you is absolutely correct that it's much easier to have this taken care of, you know, in the present before the person passes away. If it's not possible, though, you can create a will. You can name your spouse as your executor and say that they're going to inherit the home. When you pass away, they will still have to bring things up to code because there will be the inspection, and if it's a legitimate safety issue, you know, that will have to be fixed. You may be able to deal with that through something like mortgaging or refinancing, through a private loan, through, you know, friends and family helping out. So there could be some other options down the road that you don't have right now. Or it might be a situation where the person says, maybe I'm just going to sell this and move somewhere, you know, in a downsize, move somewhere different, or move in with other family, or whatever the case may be. Another option might be for a common law spouse or other occupant to buy the home from the estate. So if you are not the next of kin, let's say that if I'm living in a modular home with somebody as a roommate, and I'm not their spouse, we're just, you know, happy living together, comfortably, roommates, and I want to keep the lease going after my roommate dies, but I've never been on the lease, I'm just an occupant. Or maybe I was like the minor child years ago when the lease was signed, and now I've become an adult, and I am capable of being on a lease legally, but we've just never gotten around to that, and now my parent has passed away. If the executor is somebody other than that occupant, and the landlord is having difficulty understanding that the current occupant wants to become the tenant, or they can't for some reason, they have credit issues or whatever, they might want to buy the property in common with somebody else who can co-sign for them, especially if there's somebody younger establishing credit. They might, there might be just kind of logistic reasons that makes more sense or is easier. Again, if you can deal with it before somebody passes away by getting the name on the lease, that's the easier thing to do.
So if the common law partner is the executor, can they still buy the home from the estate?
Yes. So if a common law partner is an executor, or if anybody is an executor and wants to buy an asset from the estate, whether or not they're expected to pay fair market value would depend on whether there are other people with an interest in the estate. So if I've left my estate to my common law spouse and my child together, the child could either agree, yes, please feel free to buy the estate for $1, I don't care, you can have it. Or the child might say, well, no, you know, mom left us this jointly and I would like my share of things. So in that situation, the common law partner could buy out the child. So you're allowed to agree to whatever you want to among your friends and family. You don't have to pay fair market value unless the other person has some sort of property right and is requiring you to do that. Landlords are not permitted to interfere with a tenant's sale or disposal of a property. They may not unreasonably or arbitrarily refuse to sign a lease with a new owner. So again, that list of reasons they can refuse is the only list there is. They can't make up other reasons. They can't unreasonably allow a new owner to become a tenant.
Now, when someone passes, if the operator is very quick to send the Form A, the notice of abandonment of property, and there's a checkbox for land lease, if it's in a land lease community or trailer park, and then it says list of further actions, probable demolition, and there's a date of 60 days, all of a sudden the person would think, oh, they're gonna tear down this place in 60 days. So I have a 60-day timeline to grieve the loss of my loved one and figure out what I'm gonna do next, is what the impression is given. So
Yeah,
what's the
I would understand that to be more of the landlord's intention rather than what they actually can do if you challenge them on it.
It's not an order that,
No, it's not an order from residential tenancies or a court. It's
Or
just
demolition.
it's the landlord saying, this is what I want to do, and if you don't stop me, I'm gonna go ahead and do it. But if the next of kin or the estate or the other tenants or occupants say, well, wait a minute, that's not what we're doing. You've not gotten notice that the lease is terminated, or I have a new buyer who's gonna move in, or, come do the inspection and we'll fix the safety issues if there are any. The landlord can't go ahead and just demolish it because they want to. And again, if you can't work this out with them, you file your complaint with residential tenancies. So dispute resolution, part one. The first thing is
what if they tell you that you have to put a pitched roof on?
you would figure out if is it required by municipal bylaws, is it required by community
Exactly.
rules?
Or safety.
Or safety.
Safety or municipal bylaws.
Yeah.
They can't just say, because we want every trailer in the park to have a pitched roof, you gotta put a pitched roof on.
Yeah, that I would apply to residential tenancies if it was something like that. If the community rules say, like as of 2025, all new properties coming in have to have a pitched roof, okay, they can enforce that because it's for new homes coming in. But you can't require existing tenants to retrofit a home that's purely for cosmetic reasons. So old homes would be grandfathered in. If you decided the owner of the home has passed away, I'm gonna sell this home and put a new home on my lot that I lease, they could certainly require the pitched roof on the new home if it's an actual community rule. But existing homes, they can't make you make just cosmetic changes.
Thank you.
No, the community rules are made up by the landlord, and there should be reasons for them. Like some places, if you live in an apartment building, sometimes they'll say no real Christmas trees because we don't want pine needles everywhere. Like, okay, sure. If you live in a land lease community, they might say, you have to keep the property in a certain state of cleanliness. You can't have like a car up on blocks and 10 bags of garbage out front. Like, sure, there's reasons for that. But if it's things like every home has to have a pitched roof, maybe they're trying to increase the property value and they can apply that to new homes being brought in. But like I was saying, you can't grandfather in grandfather in new, purely cosmetic changes for older homes. Rules should be the same for everybody in the community, except where there are situations like this where somebody's grandfathered in with a rule that's been more favorable to them. So if the community says something like, we used to allow people to have dogs, and then we had a lot of trouble with aggressive dogs and dog bites and all kinds of things, and we don't want to have dogs anymore. They can't make you get rid of the dog you already have unless your dog has had actual behavioral issues or safety problems. But they can say new tenants can't have dogs, and if your dog passes away, you can't get another one.
And then, so if there's the list of the community guidelines, just because they say it, doesn't make it that it doesn't go against the Residential Tenancy Act.
Yeah.
So the community guidelines for Westfall Court Limited have not been gone through to see if they meet the Residential Tenancy Act requirements. No one successfully has challenged that yet. Bill 467, Brian, was it? Bill 467 that just went through in the fall. There's a common anniversary date now for all community rules. It's supposed to be posted publicly, I think it might be at the office, and everyone's supposed to get their method of communication. If you haven't committed to email communication, it's supposed to show up in your mailbox that they make you put on your porch, right? Or through regular mail. So now everyone's gonna have the same community rules across the park, everybody. So when they make that rule, now we have to kind of go through them and see if they are against the Residential Tenancy Act to file a Form J. It can't be done as a group. You need an individual to file. That's how it's set up now.
That being said, if multiple individuals have the same problem, they can all file individually. Residential tenancies might say, we're gonna look at them all.
It's all individual filing.
Yeah.
It could be common issues, not to talk about the water meters, but that's what was tried for the group stuff. But it is individual. Somebody in the park has to file. There isn't a government body or a regulation or an enforcement unit that will overlook it and say, no, that one goes against the act. It has to be done from a resident.
And if I may, that rule was changed or amended because of the work that was done by this committee and everybody in Woodbine. And this rule now applies for everybody in the province. So it's a good work, what you guys are doing here right now.
Thank you, Brian.
Yeah, so the examples I had, if a landlord refuses to sign a new lease with a remaining tenant after somebody passes, you apply to residential tenancies if you can't work it out. If they try to terminate the lease after the tenant dies, but the personal representative has not given their notice and the statutory time limit has not run out to terminate the lease, you can apply to residential tenancies. The other example, the landlord and tenant can't agree on whether the repairs or upgrades are necessary. Residential tenancies will give you a decision about that. The tenant and landlord must both, and I mentioned this earlier, must both wait for a decision and any appeals to be completed before taking any action. So if you get this notice that says, I think the property's been abandoned and I'm demolishing it in 60 days, and you say, wait a minute, I don't agree to that, you try to work it out with them. If they say, oh, okay, I didn't realize I was not doing the right thing, and we'll call that off. Best case scenario.
Yes.
Yeah, do get things in writing. If they
Take videos or audio recordings.
Yeah, if they say, nope, I think I can demolish this, you can file with the Residential Tenancies Committee, and they are stopped from doing anything until you get that decision. And then if you're appealing to small claims, they are still stopped from doing anything until that is complete. After small claims court, the next place you would appeal if you were going to would be the Nova Scotia Supreme Court. Most tenancy matters don't go that far. They're usually resolved by the time you get to the small claims level, and the small claims court is, they apply a fairly robust analysis to the situation, and my experience with them has been that they are understanding that people are representing themselves. So if you need to appeal and you show up for your first scheduled date and you say, like, I've been looking for a lawyer and I haven't been able to find one and I need more legal advice, can I have another month and reschedule this? They're often happy to do that. They just are looking for you to keep them updated. So don't skip your hearing dates entirely just because you can't find legal advice or you're overwhelmed. It's important to go to anything that's scheduled to update the court and let them know if you need more time for whatever reason.
Also, the weird thing too for small claims courts and hearings, for the initial hearing, it's like a conference call. He has like this docket, and so he calls it, she goes down the list of people, are you here, are you here, are you here? Okay, on this matter, hey, you've attended your first thing, is there something that we need? Okay, good. Goes down, so you're sitting there listening to the whole thing until they come to address your issue. So there's ways and systems that goes, you'd figure, hey, just like you would go into the courthouse and figure this stuff out. Now it's done over the phone in this matter too. So it's a bit of a surprise and kind of like, oh, what am I doing? But that's how these things start to unfold over phone now.
Yeah, and I see your hand there, I'll be right with you. If you do end up having to go to small claims court and you're going to be going in person, small claims court is open to the public. So you could look up when the times are, and you could just go watch some small claims matters so that you have a better understanding of how the court works and how to address the adjudicator and how to organize your notes and things. So if you're a bit nervous or you're not sure what to expect, you can just go watch some other small claims matters and get a sense of how things go. Another thing to keep in mind about residential tenancies or small claims is that you are never required to pay the legal fees of the other party. So your landlord might hire a lawyer and have them come to a hearing, and they might say something like, well, if we lose, you're gonna have to pay our legal fees, so don't sue me. That's not a thing that happens in residential tenancies or in small claims court. The rules of court do not allow that. So even if they have a lawyer and you lose your case, you're not gonna be on the hook for their legal fees. So the last slide here is just the website for the Legal Information Society, so legalinfo.org again, and you can find our contact information there. I might just bring the site up really quickly to show you how to navigate it, if that's all right. So this is the homepage of the website. Right at the top there where the question mark is, it says Ask a Legal Question. If you click on that, you can see it says ask by telephone, by email, by live chat. We have a youth text line as well if you know any young people, so that's people up to the age of 25. If they have a question, they can text us. We don't police the ages of people, so it's intended for youth, but it's not the end of the world if you say, I have a young person, I'm asking a question on behalf of them or something. If you want to search on the website for different topics, you can use these icons on the front. So we have a bunch of things there about housing, and you'll find residential tenancies help and tenants' rights guides. And then if you want to search by keyword, in that drop-down menu on the side, there's a search button. If you click on that, that'll bring up sort of the search bar you're used to, like on Google or anywhere else, and you can type in what you're looking for. If you have issues with accessibility as well, like if you need to use text-to-speech or something like that, that's something that you can easily do with our website. That's all the material I had. If you want me to, I can answer some questions, or I can run through the slides that you had from Legal Aid. So I didn't prepare these slides and haven't seen them, but we can run through them really quickly in case you weren't here before. There might be something that I learned from them, which is always nice. So my understanding is this was prepared by Dal Legal Aid?
Yep.
Okay, and it's when a manufactured homeowner passes away. So this is the section of the Act that deals with the notice by personal representative that we were talking about. So the landlord's not obligated to enter into a new lease on the same terms and conditions as the original lease, but they also can't refuse a lease assignment. So you have a little bit of room there to try and work things out with them. If it's a month-to-month lease, which is not something I talked about, the tenancy can be terminated on a month's notice after the sole tenant dies. They've got the section about tenant that says it's an individual is paid or agreed to pay rent, is permitted to occupy or sublet with landlord consent, or an heir, assigner, personal representative.
Yeah, because it's that after someone's passed, it's if the landlord is required to accept rent from the estate or the person living there. It's a big difference. If it's the estate that pays the rent, or if it's just the estate hasn't been established yet. Mm-hmm. Does the operator have to accept lot rent if it's offered, or is it just tacked on to a bill that's put on after the estate's settled? Because they send that notice of abandonment form, which all of a sudden makes people think, I got 60 days. So are they supposed to wait for the estate to get set up and settled and not harass people until that's done?
They shouldn't be harassing people generally. When somebody passes away and their estate is taking on a contractual relationship, then the estate would be the body that you would expect to be paying. If let's say your married spouse passes, if you're the surviving spouse and you're the executor, you're the same person, so it doesn't matter. You're going to keep paying the rent. The landlord should still be accepting that because you are likely going to be taking over the lease. If it's, let's say my mom lives in a modular home and my mom and dad live there, my dad passes away, my mom wants to keep living there, she's not the executor because she found that idea very overwhelming, so I'm the executor. So I would be the person dealing with the landlord on her behalf and helping her get that sorted out, and I would be the person paying the rent to the landlord for the estate until the property was transferred from the estate to somebody else. So maybe my mom is e-transferring me the money and I'm sending it to the landlord. But the landlord can't say, I refuse to accept rent so I can evict you. The landlord has to, follow the rules about accepting a new tenant.
Okay.
What if they don't?
Yeah.
Form J, you go to residential tenancies.
Form J.
Yeah. You pass away, your estate is now the owner of the trailer or the modular home. They can sell it, they can have somebody else move in. The park can't just claim your property and say it's abandoned because there's clearly somebody who owns it now. Yeah, if you have property that you're giving to someone in a will, nobody else can come along and say, oh, free, mine. It's up for grabs now because you've clearly said somebody else is the new owner. Yeah. The slides here are talking about occupant who might not be suitable, eligible to be tenants or don't assume the legal obligations of a tenant. So minor children, potentially roommates, potentially short-term boarders. So some options, and we've talked about these a bit, apply to add a tenant, a lease assignment. Something I didn't talk about was a de facto tenancy, so it looks like there are some slides about that. Legal aid, and I don't want to get too deeply into it because I didn't make their slides. I don't want to, give the impression I'm speaking for them. So I'm just going to talk about what's right here. So they give a case from 2023 where the case said that the lease is a contract in addition to being a property interest. When a party to a contract has the power to make decisions, that's what they mean by discretion exercising, the power has to be exercised reasonable. And that's in line with what the Residential Tenancies Act says. A landlord has to act reasonably. This means acting honestly, not arbitrarily, consistent with the purpose of the power. In this case, the Small Claims Court of Nova Scotia found that this principle does apply to a landlord's power to approve occupants under a lease. So, like one person was saying, if you have an issue, go to residential tenancies. If you feel that the law was not correctly applied at that level, maybe there was some set of confusing facts or this was a new issue that residential tenancies had not addressed before, you can appeal to Small Claims Court, and Small Claims Court can issue decisions that have to be followed going forward. There's some sections of the Residential Tenancy Act here about assigning a lease outright, so the tenant can apply in writing to transfer the lease. The lease continues to apply on the same terms and conditions. So when a landlord tries to say something like we talked about earlier, the lease is going to run out and they have to sign a new one. Well, no, the lease continues as the lease always has. Within 10 days of receiving the application, the landlord has to consent to the request or set out the reasons why they're not consenting, and that's that list of conditions that we talked about. So those are the only conditions they can refuse. And the landlord can only deny a lease based on those conditions. I'm not going to read through these all again because it's what we talked about. Yeah. So the determination of a de facto tenancy, so a tenancy that might not exist because it's in writing, but it exists because of circumstances, comes from the wording of Section 3 of the Act. A tenancy can be established even if the tenant is not on the lease, if there's some form of possession or occupation and the payment of rent or an agreement to pay rent. The scenario that comes to mind is you've lived in this unit with somebody, they have passed away or moved out, and you've stayed on and paid rent. The landlord is aware of this, has allowed it to continue, but has never bothered to sign a new lease with you, but they've treated you over time as a tenant, in which case the Residential Tenancies Act and program is going to say they can't change their mind after they've committed to this course of action. If they've treated you as a tenant, you have become a tenant. And they make the point that ownership of the manufactured home is separate from the issue of tenancy. So in the situation where my mom lives in the manufactured home, I live somewhere else, but maybe I'm the owner, it doesn't mean she's not a tenant if she's the one paying the lot rent every month. It just means that, ownership of the physical building is between me and her. So there's more here about how you might determine a de facto tenancy. The first one, you occupy the premises and you've paid or agreed to pay. Another scenario is somebody's granted the right to possess or occupy by agreement with somebody and in exchange for the payment of or promise to pay rent. So that might be like a subletting situation. That might be a sublet is kind of the most typical one. It could be more informal, like I'm going to be gone for 6 months working and my sister's going to come live there and the park knows about it and they're fine with it. The individual has possessed or occupied the premises and has agreed or that looks like it's the same as A actually. Yeah. Okay. So yeah, if the person is living there and they've been doing it openly and the park or landlord has accepted their money or said that they are going to be fine with accepting their money, then that person can become a tenant just by the fact of the situation. And like somebody pointed out, it's a good idea to make sure you have things in writing. In writing doesn't always have to be like a registered letter either. It can be like a text message or an email. It just has to be some form of communication that you can prove. There are a couple of cases here. The first one is about Woodbine, and that happened in 2019. The individual moved into their parents' manufactured home after the parent passed away. They paid rent until 2019. Then the landlord started refusing to accept the payments. The adjudicator found that the individual was a tenant because the landlord had accepted the payments previously. This one is related to Westfall. In 2020, the individual's parents were the original leaseholders and owners of the home. The individual had lived their entire life in the manufactured home. So that's sort of like that scenario we talked about where a minor child is just an occupant, they can't be a tenant, but then they grow up and they do have, the ability to contract. The individual's mother passed away and they became the sole occupant. The landlord refused to accept rent directly from them and insisted that the payments come from the estate. The individual presented evidence that they had contributed to the rent for quite some time prior to their mother's passing, and the adjudicator found that the individual had become a tenant prior to the death. Tenancy vesting with an executor. So the concept of vesting in law is a right is now belonging to you. So while a residential tenancy starts with an individual, it can later involve another person who obtains that right. And that's sort of the situation that those cases we're talking about. So the person who lived with their parents might not have been a tenant when the lease was signed. They may not even have existed when that lease was signed. But the right vests in them at a certain point, meaning they have that right, it belongs to them now because the facts have changed and they've lived in the home and paid rent and the rent has been accepted by the landlord. Executors of an estate are people. And in some instances, they could find themselves having the status of a legal tenant, which would give them the same rights and obligations of a tenant. So in that situation where if my mom is living in the home and I'm the owner or I'm representing the estate of dad, if mom doesn't want to deal with it and pay the rent, then she's going to be the occupant and I will be the tenant because I'm the one paying the rent on behalf of the estate. So you can get into all kinds of like specifics and particulars of relationships, but the main overriding factor is a landlord has to act in good faith and they have to be reasonable and not unfair.
Is professional a requirement at all?
People's understanding of professional may be different from person to person.
I'm finding it's very different.
Yeah. A landlord has to behave with a certain kind of minimum amount of decorum. We'll call it decorum, yeah. So a landlord can't infringe on your human rights, for example. They can't insult you based on protected characteristics. They might say, I don't like you, but they can't not rent to you for that reason. There's a slide here about a lease transfer network. The tenancy, when a lease is assigned, the tenancy continues on the same terms and conditions. When a new tenancy is created, the key terms of the tenancy can be altered. I'm not familiar with the network that they're talking about on the slide, so I would leave that to Legal Aid.
That's another, it's something in Montreal, I think where Mark was from, that there was a group that helped.
Okay, yeah, so it's, you guys have, this Woodbine group seems like it's accomplishing some really fantastic things. And as far as tenant advocacy goes, there are different things happening in different provinces. So, doing some searching online and looking for what other tenant advocacy groups have done might be helpful if you're trying to come at things from a new angle. That was all those slides, and again, I didn't make them, so I can't speak too much about them. If you've got questions about my own slides or about kind of estates or tenancies generally, I'll do my best to answer them. Yeah, so you can deal with your will in a couple of ways. You can have specific gifts, and then you have everything that's left over, and that's called the residue. So if you don't have specific gifts that you want to give away, like you might not want to say like my jewelry goes to so-and-so and my painting of Jesus on velvet goes to so-and-so. If you have sentimental things that you want to give away, certainly specific gifts can be the way to do that. Or if you have things of particular value or you want to give a cash gift, like, I leave $100 to my nephew. You do those, and then everything else is called the residue. So you can include your home in that residue, or you can go give your home away as a specific gift. Or if you don't have specific gifts, you just say, I give everything to whoever. So if this is the situation, I think, where they say, we've done our inspection and there's all of these things you have to do that are very costly. If you don't agree that those things are necessary to comply with municipal bylaws, park rules, or safety concerns, then you can apply to residential tenancies. So you can do that as a tenant, or you can do that as like the estate who has become the tenant. There's no specific timeline for estate work to happen, and there's, as far as I'm aware, there's no specific timeline for probate or for an inspection to happen. So if you've notified the landlord that somebody's passed away, and you say we're going to sell it, they might say, okay, if you're putting it on the market next month, we're going to come look at it now and do the inspection. But they can't just require you to make costly repairs or upgrades or renovations that are not actually needed for some legitimate reason. My understanding of that would be that's sort of like if you have a new home, they can require new things. If you have an old home and there's not like a safety or municipal reason for the gutters, then they may not be able to require you to put them on. If they're really insisting on it and you don't feel that it's necessary, then you can ask residential tenancies for a decision.
Form J?
Yeah. The answer, unfortunately, is often going to be apply to residential tenancies. Yeah. On the lease, not necessarily a tenant. So yeah, she's a guarantor on the contract, meaning if you don't pay, she's on the hook to pay it, but she doesn't necessarily live there as a tenant. But if you passed away and your minor children are too young to deal with it and take over things, as the executor, she's going to become, the estate's going to be the tenant until that matter is resolved. So if you get this situation you're describing where the landlord sends out a notice saying, you've got 60 days to deal with this. Your mom can say, well, I'm the executor. I need time to make other arrangements for the children, to sell the property, or maybe I'm going to move in there and look after them, whatever the case may be. So no, you can't demolish this. You can't do this in 60 days. If there's going to be probate done, they can let the landlord know of that and just keep them updated. And the landlords, they have to act in good faith and act fairly. From what you're describing, it sounds like she's a guarantor, not a tenant, but I don't know what's actually on your lease. You should just take a look at it. If you want to have her taken off, and the reason is that you no longer need a cosigner to qualify for the lease, then my expectation would be that you'd be covered by the rent cap and the community rules that were in existence. I see, I'll be right with you there. They can make rules like, the Christmas tree rule. That's not a thing where people could be opting out because they'd live there forever. But if it's a thing like, now we want everybody to pave their driveway, I would expect that to apply to incoming homes rather than the existing ones, because it's not for a safety purpose or, trying to save money on cleaning costs or something. It's just for how things look. Yeah, my expectation would be that they should be agreeing to just remove her if she's no longer needed, and that they can't require you to sign something that has, difficult conditions or increased rent. If they're refusing to do that, then apply to residential tenancies. Yeah, sometimes a thing isn't worth dealing with. So if you have an issue that you want resolved, and applying to residential tenancies would be the option. But if you say, I'm not on bad terms with my mom, it's fine if she stays on there, I don't want to deal with it, that's also fine. Yeah, I wouldn't expect your mom to be able to apply to residential tenancies for a tenancy issue you're dealing with because she's not living there. But I would expect her to be on the hook for the bill if you don't pay. And if you pass away as your executor, she could then deal with tenancy issues. Does that make sense? People will often ask us, can this person sue me for that? Or can I sue them for this? And the answer is, unfortunately, anybody can get into a dispute with anybody else or sue anybody else for anything at any time. It doesn't mean that they're going to win or that they have a valid case or that they're in the right. You can't always prevent difficult situations, but you can at least make sure you have the knowledge and information to know how to respond to them and know what your rights are. So your landlord might be difficult if that situation happens, but your mom can then say, I'm not dealing with this within 60 days. Like, I'm going to keep paying the lot rent, and you're going to be required to accept it. That's a good one. I don't have an answer. You'll have to maybe email us, and I'll look into that for you. Thank you. Anytime I've rented, I've not been asked to complete a criminal record check.
You're here.
Yeah. I would contact residential tenancies and ask them about that one probably.
Okay.
Yeah. No, that's not true. He's wrong. Yeah, so if you are divorced or you were common law and are now no longer together, the person does not have any rights to your property. So even if you didn't make a will, they don't have any rights. The minor children, if you don't have a will, might inherit. Okay, so if you've made a will and it's going to somebody else, the ex-partner or ex-spouse does not have any rights to anything. If you inherit a home as well and you feel that it's worth more than the park is willing to offer you or somebody else is willing to offer you, you can sell that privately somewhere else. You can ask the land lease community to make you a fair market offer, but you're not required to just sign anything over to them.
Right.
A lot of them are, I realize, quite situation specific in dealing with, family members and occupants and residents and tenants and all these different things. So if you have a question that, occurs to you later, or if I didn't know the answer to it, like the criminal record check, certainly feel free to send us an email. You don't have to. So the question was, in your will, she's getting the home, but she's not on your deed currently. So that can be done now if you want to deal with the effort and the cost, or it can be done after the fact. Okay. If you've got legal advice and I wouldn't say something different than what your lawyer told you because I don't know all the particulars. If you feel that your landlord is, not agreeing to something and it's not reasonable and it's arbitrary, then you can apply to residential tenancies for a decision on that. If you feel that you don't want to deal with it now, it's something that can be done after you pass away. But, if you don't want people to have to deal with that and you want to deal with it now, you can do that through residential tenancies. First of all, try to negotiate with them about what's actually required and necessary. So if somebody said, here's a list of $80,000 worth of things, and I said, well, I agree with 10,000 of that. This thing is really a structural issue and this thing could be fixed, but the rest of it is just stuff you think would look nice. See if you can come to some kind of agreement with them. If you can't, then you could apply to residential tenancies for a decision on, what actually needs to be done to comply with the municipal bylaws and safety and park rules. Anybody else? It looks like maybe my time's up. So if you have other questions, feel free to just send us an email or get in touch through the website.
Got to clean up too.
Yeah.
So thank you very much, Nicole.
Yeah.
You've given us, you've really given the information we've needed. Thank you. Thank you very much. So what do we do now, right? So it's obviously a talk with residential tenancies. It's obviously, how do we share the information that we've learned today where you can say, hey, I went to this session. So we got Matt Dagley from Dagley Media to come and video this. So I think, Matt, what we will do for everyone's personal questions, we're going to put them typed on the screen. And then Nicole's answer to hide, to protect the people that are here. And we're mindful and respectful of that. Because there are people here that aren't here now because I can't do it.
They're scared.
Scared to death.
Yeah.
Management's already giving them a hard time. And then they've heard the stories of everyone having a hard time. We're trying to flip that. We're trying to flip that. We're trying to give people support. Right? That's what we're trying to do as a community, is to give the support, to give good information, and now we can start recording this good information, things like that, so we can share it. So if you have a friend that lives over in Sackville Estates, you can say, hey. And are we trying to make sure that we can share information around to the rest of the other communities around the province? Yep. Yep. And we need people to tell us the stories so we know. And then not just tell us the story, but we take your email address, or you send us an email, a contact that we can say, doom, here's your resources you should contact. There's a lot of stuff you do have to do on your own. We can't do it all, right? Where are we going to head to Bridgewater the start of February because they're having troubles down there? But you have a group of another community that has a few people that are like, wait a minute. And so it's getting the MLAs, that's why Brian comes, it's getting the MLAs, it's helping our HRM counselors, the municipal counselors understand, because people are like, I don't know if I call the city or if I call the province, right? So it's figuring all that stuff out. So I hope everyone found this very worthwhile. Thank you very much for coming. We appreciate you.